The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Right.
I don't know if people aren't calling because I'm only talking to dead air, or if people are listening to me with rapt attention because I am so fascinated. Who knows? Cliff says that's it. I don't know.
Yes.
All right. So if you think that you shouldn't be evicted and you really want to fight it, then again, it depends upon how complex the issues are as to whether you should do it yourself or whether you should have a lawyer do it for you, or at least go in for a consultation and figure it out.
No, I'm thinking, why do you want to continue a relationship with this landlord, but you're obligated to that contract?
That is a great point. That is a truly great point. One of the few you've made in 24 weeks. All right, here's what I tell people. If the landlord is demonstrating his jerkiness, and you can see that you're going to have continuing problems in the relationship, you may be better off getting out from under that landlord, even if you're happy with the place you have. And again, that involves an early termination of the lease and negotiating that. Now, are you required to? No. If you're doing everything right, even if the landlord tries to evict you, you'll win. And no, you're entitled to stay there. And some people will because they have a strong constitution and they're willing to fight.
I was going to say the fight might be fun.
It might be. My perspective, see, this goes back once again to the sign outside my door, my office. Attorneys and counselors at law. In the olden days, that really did have a distinction. Sort of like the distinction in England between barristers and solicitors. Solicitors get the cases, barristers try them, okay? There is a difference which has been sort of muddied over in our country between attorneys and counselors at law. As an attorney, I'm going to give you my legal analysis. I'm going to give you the legal options. I'm going to give you the pros and the cons of each option and guide you to making your own decision. But as a counselor, I perceive it also my obligation to look at you and talk to you about the facts of life. And if you have every right to be in that house, and you love it in that house, and your kids are going to this high school and you don't want them to move out of that high school, those are all excellent reasons to stay where you are. And if that's what you want to do, wonderful. I'll do everything I can to effectuate it. And if the landlord starts retaliating against you or causing you more problems, I'll be there if you need me to fight back. But I will also talk, to these tenants and simply say to them, practically speaking, do you want to continue this relationship? Do you want to live like this? Or would you rather find another place? And if they would rather just be done with this and this was a bad decision, let's just move on, then my suggestion will be, let's use all the ammunition we have to try to negotiate the best early termination we can, where the landlord just kisses you goodbye and you leave. You have no further financial obligations, and maybe you even get your security deposit or part of it back. That's my practical advice to a client. Client's free to accept it or reject it. I'm not going to make a value judgment over what's right or wrong because I'm not in their shoes. But I perceive my obligation to be not only to provide the legal analysis, but the factual realities of life. And you then do what you want to do with it. I sometimes I talk to clients about, I try to give the analogy, You might go into the casino and go straight to the $100 blackjack table. I go into the casino and go to the $5 blackjack table. And if they have a $2, I'm going to go there. But very few of them exist
I like
anymore.
nickel slots.
Yeah, I hear you. And so my level of tolerance for pain when it comes to gambling is very low.
Sure.
I'm willing to lose enough that I perceive it as the value of entertainment.
Exactly.
Some people either are willing to go beyond that, or some people have a different value of entertainment because they're able to. And so if you are willing to risk more and let it ride, it's not my decision to say to you, I wouldn't do that, because I'm not you. My only obligation is to give you the options as I see them, point out things that maybe you haven't considered, give you the tools legally and practically to make your own decision, and then tell me how to implement it. Or tell me what you want implemented, and then I'll use my best methods to try to implement it.
Now, financially, do you believe that fighting to stay in that rental would be more beneficial than to just cut your losses and leave? I mean, because moving is expensive.
Yes.
Fighting your landlord in court could also be expensive.
Both financially and emotionally.
Okay.
It really depends upon what is going on. If the landlord is truly being a jerk, and I would use a much stronger word, but I can't. So if the
we would rather that you didn't.
I know. If the landlord is that kind of landlord, I would probably try to urge you, your decision, but to get out if you can.
Because, I mean, even if I go to court and win, my lease will expire at some point.
Right.
And that landlord's going to want me out anyway.
Yes, unless the issues are not so serious that the relationship can be repaired. And the relationship is not really going to be repaired in a court hearing where one wins and one loses. The relationship is going to be repaired, if that's possible, through talking to the landlord, either on your own or with an attorney. And sometimes when I'm asked to do something, there is a time for the letters I love to write, which are nuclear weapons designed to terrorize the person who receives them. I love them, and I'm known for them. But sometimes the proper tactic initially is diplomatic. Now, there are some in our country who don't understand that and don't know how to do it, and all you have to do is turn on the news today, and you're going to hear about that because it's the truth. But there are diplomatic ways to explain small differences of issues and opinion, and not antagonize a landlord, so that you may be able to work this thing out and still move forward in a relationship. And if that's what you want, and the issues in dispute are such that it could work, then I tamp down my personality and I become, at least temporarily, Mr. Type B, which is tough, but it's easier in a letter. And I try to do that because it's the best strategy for the moment in how to handle this situation. I love going nuclear, but it is not always the right strategy.
Yeah, but it's when
Right.
you need to do that.
And sometimes you get these prospective clients who come into the office, I want a warrior, I want a fighter, I want to kill. Or as I like to say, I want to kill, decapitate, destroy. And if the situation warrants it, I look at them and say, you got the right guy. But sometimes I'll look at the situation and I'll say, hey, I'm happy to do it. Fully capable of doing it. But you might want to consider a different approach. And very often when the situation warrants it and I give that advice, the prospective client, who hopefully becomes a client, calms down a bit. They've had a chance to express their anger and their frustration. and they say to me, okay, do it that way. And we at least give a chance to keeping the relationship together. And that happens landlord-tenant, employer-employee.
Mm-hmm.
Doesn't really happen when it's inmate-guard, but then it's only nuclear. Can't really be nice. But those are the different types of options. Now, let's say you win your little eviction action. Do you get all the rent back that you put into the registry of the court?
No.
Oh, no, 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 no. Now the judge has to determine, based upon any other issues you've argued, were you entitled to some abatement of the rent? And if the judge decides, as I said, 25%, then it's going to direct the clerk as to how to distribute the money in the registry of the court. If the judge determines this was not a situation where you would be entitled to an abatement of rent, then there'll be no abatement. And
the landlord will be paid.
The clerk will advise, the judge will advise the clerk to disperse the monies in the registry of the court to the landlord. You may not have been evicted because you've proven your case, but you may not have been entitled to an abatement, because not every issue leads to that. But you have to do all the procedural niceties if you want a chance to be heard, if you want a chance to prevail, and if you want a chance at that rental abatement.
Okay, let's go back to your example about the mold. Okay, you win. You'd like to stay. All you want is for your landlord to fix it. You win. When does the landlord fix it?
All right. Typically, injunctions are not really a part of landlord-tenant court. And in that situation, you're probably going to get a very significant rental abatement. Maybe the whole thing, if the place was substantially uninhabitable. But let's say it wasn't, and you were able to live there, but your kids were getting respiratory illnesses every 6 weeks.
At the doctor.
Right. The court is going to look at that, and the court is going to determine the rental abatement. And then the idea is that the landlord now has the incentive to go fix it. Because if the landlord doesn't fix it, he tries another eviction action, it's obviously not going to work. And if the tenant then gives a 7-day notice and the landlord doesn't comply, the tenant will be withholding rent. So at that point, the landlord has seen the writing and hopefully makes the repairs.
Okay.
All right, so now let's go to sort of the last area of landlord-tenant law. It's an interesting one, I think, because it comes up more than one might think. What happens when you want to get out a house guest, a family member?
Ooh, so you're saying your own residence, you own the place, you let your cousin come stay in the spare bedroom.
Or your son reaches 18 and...
Well, there's always college,
Well, I know.
They got to go away for that.
Or the 35-year-old son wants to come visit and then overstays his welcome. And you want to get a house guest or an adult child or...
a friend.
An ex.
Ooh.
Out.
That's different.
How do you do that?
Okay.
It's not as easy as people think.
Yeah.
Okay? And we can go through 3 sort of ways of doing this. I think, let's see, we had here. Yes, we do. First, we're going to look at, is that house guest, child, friend, ex, are they a tenant? Have they qualified as a tenant so that you must use landlord-tenant procedures?
Okay, no, because we just brought them in. Because we were being kind and loving and caring and gave them a place.
Not necessarily, Kimasabi. Okay, let's look at, did they pay any rent? Did they contribute?
Usually no.
Did they contribute towards household expenses?
Okay.
Do they have a utility bill in their name? It can get confusing. A lot of times you may have a long-term house guest. So they're paying you some amount of money every month. It's not necessarily denominated as rent.
Okay, well, let's say they pick up some groceries every now and again.
That could be sufficient to be considered technically rent. And what's really important is if it is rent, if the law will view it as rent, then the only way to get these people out is to give them the 7-day notice and use the eviction action procedures, have the suit filed for eviction, and have the court evict them. You cannot use self-help. If you use self-help, you may end up in jail.
And by self-help, you mean take their things and put them at the curb?
Right, change the locks.
Okay.
Get physical. It doesn't work that way. It gets complicated. Now, what if they are not technically classifiable properly as a tenant? Then what are they?
A nuisance.
An interloper?
My ex-best friend?
Somebody who sucks off the goodness of your heart?
Yeah.
But what are they legally? Oh, we have a question here. What if they have a utility bill in their name and you want them to leave but don't want to evict? Very good question from my 14-year-old son. What happens is they're a tenant and you either negotiate their departure in a way that is workable for both of you or you evict. That's the answer. Now,
And go get the utilities put in your own name.
yeah, it's something to consider. But again, even so,
But I can see how these things could happen. You would be like maybe if you were living together, partners, or if you were roommates.
that's right.
Okay.
It can happen in a host of circumstances. This is not just the prototypical, I'm breaking up with somebody and I want them out. I mean, it happens that way. But it's, I have a roommate and
It's my house.
I don't like them anymore. Or I have a roommate and they're just taking advantage of me. Or I allowed, my cousin from New Jersey wants to escape the snow. And so they're coming down in January for 2 weeks. And it turns into 2 months. You got to get them out. How you get them out depends upon how they can be classified. If during that 2 months they were giving you $500 a month, they're probably a tenant.
Okay.
If they were regularly buying the groceries, they may be a tenant. This is sort of like Jeff Foxworthy. It just hit me.
You might be a
you
redneck.
might be a tenant if. Now, I'm not Jeff Foxworthy, so I won't even try to do the funny stuff. When I'm funny, it's by accident. Yes. Thank you. But you might be a tenant if. So what happens if you're not a tenant? There are 2 other statutes that apply. One is simple, one is more complicated, and they both apply in different circumstances. We won't spend a lot of time on them because they're not as common as landlord-tenant, but I'll sort of give you a synopsis. Unlawful detainer, as opposed to landlord or tenant eviction. Here's a common example. You and your significant other that aren't married, you're living with each other in a property that you own. There's no formal obligation of the other one to pay rent or whatever. And they don't have any utilities in their name. It cannot be classified that anything they've done is the equivalent to paying rent. So you can't use the landlord-tenant statute. So you use, in circuit civil court, unlawful detainer. It's a tort. And you argue that they don't have a right to be in the property. So that is also handled in a summary procedure, similar to landlord-tenant because the court wants you to be able to get out relatively quickly, somebody who really shouldn't be there.
Mm-hmm.
And the procedure goes very much the same way in terms of the trial. You're going to explain the factual situation, and if it's not a landlord-tenant situation, and the judge agrees with you that you have a right to your property free from this person, maybe it's your mother, or your mother-in-law, or your ex-mother-in-law.
And their defense will be, I don't have anywhere else to go.
I know. Judge, very sympathetic, but that's not a legal defense. The judge will not evict, because it's not landlord-tenant. The judge will enter a judgment of unlawful detainer and a writ of possession. You're entitled to possession. And again, sheriff, show up, rinse, repeat.
Okay.
Okay? Now,
I kind of feel sorry for the sheriff's department for having to move all that.
Never
all
feel
that
sorry
stuff.
for the sheriff's department. And the last thing is ejectment.
Now, how long though? How long? Now you have this person living in your home, and you've got the sheriff is going to be coming. When? How fast?
Just like landlord-tenant.
Okay.
I mean, relatively quickly.
Okay.
Now, the last one is ejectment. It is different in that, in this scenario, the person who is in your house is making a claim that they have a legal interest in the property. It could be a frivolous claim. It could be a legitimate claim. But they are making a claim, not that we're a tenant or what have you, but I have some interest in this property. Now you're going through a much longer procedure. It's a normal circuit civil case. The court has to consider whether or not that person really has a legal interest in the property. And if they do, then really the only alternative is to partition the property, which means the property is either sold and money divvied up in a manner in which the court determines.
How would they prove that they have a right to the property? Would they have to be on a deed? Would they have? I mean, I would think that there would have to be some documents.
Well, documents help. I never like cases without documents. But here's a perfect example. You sort of raised it yourself. And I just, last week, settled a case just like this in mediation. A couple decide that one of them is going to buy a house and they're going to put the other on the deed. Because at some point they intend to get married.
Okay, so like joint tenants.
Well, once they're on the deed, yes, they are joint tenants.
Mm-hmm.
They're not tenants in common, they're joint tenants. Well, actually, they're unmarried. Unless the deed says joint tenants, there are tenants in common. But the differences are not that significant in this factual scenario. So since they're on the deed, they have a legal interest in the property.
Sure.
They may not have paid a penny.
Mm-hmm.
They may not be on the mortgage, but they have a legal interest in the property. The only way to get them out is to eject them. To eject them means filing an ejectment action. And either you come to some agreement as to how much money one is going to pay to the other so that they give up their interest in the property and give a quitclaim deed, or the court enters an order of partition, which means either this is how much this person's going to get from a sale, 30%, whatever. Either you pay them the equivalent of that amount that you can agree upon, or the property needs to be sold. And that's a partition action. So ejectment hand in hand with partition. And that's what happens when somebody has a legal interest in the property. Now, they assert a legal interest, and it's baloney. They created a fraudulent deed. Whatever, identity theft. The court determines that too, and if they don't have an interest in the property, obviously they're not going to win. They get ejected, and then a lot of other things, bad things may happen to them.
Right, yeah. They have other problems.
Yes, they do.
And the sheriff comes out and kicks them out anyway.
So, let's see. We were going there to... Where's the proof? I just take a look, because we were about to go, even though we have little time, to a new area. Yes, we are. And, oh, we have very little time. So let me just highlight the area then for you. Next week, same time, same station, we're going to talk about defamation. What is defamation? It could be libel, which is written. It could be slander, which is verbal. You are an idiot. That's not defamation.
No.
That's my opinion, and I am protected to my opinion by the First Amendment.
That's right.
You are an idiot and a thief. The idiot is not defamation. The thief is. Accusation of criminal conduct is a great example of defamation.
Okay.
It's also a great example of what's called defamation per se, which we will get into, because when you get into defamation per se and the circumstances warrant it, you get the presumption of malice. You don't have to prove it. And you get the presumption of harm. You don't have to prove it. Regular defamation, you have to prove the intent and prove the harm. Defamation per se, those are presumed. And defamation per se is held for the more serious forms of defamation. So we're going to talk about what is defamation, what is permitted, what is protected, what is fact, what is opinion.
If you're a public person.
Oh, I was about to get there. You jumped on my punchline. All right, so let's go right to that, and I'll get to your question if I have a chance. We'll talk about it in the car. Because you're a hostage. There is a different standard for public figures. If you accuse Donald Trump of being a thief, he's a public figure, and you have a much greater degree of right to comment. And so the standard goes from preponderance of the evidence, which we talked about way back when. I like to describe it as 50% and a feather, to clear and convincing evidence. Also, regular defamation could be intentional, reckless, or negligent. Public figure, reckless or intentional, not negligent. Okay? Now, that happens if you're suing the public figure. So, New York Times, great case, New York Times versus Sullivan, United States Supreme Court. New York Times publishes an article about Donald Trump. And he hates the article. He sues the New York Times. He is not going to win unless he can show that when the Times published that article, they knew that certain factual statements were false, or they published it with reckless disregard.
To find out whether or not it was true or false. Okay.
Not negligent.
Okay.
Okay? So it's a much higher standard. And what is really interesting, but right before we run out of time, you, the average person at home, can temporarily become a public figure and have that new standard apply. You decide to take on the city of Port St. Lucie on the extension of the Crosstown Parkway. And you're at every council meeting, and you're out there with signs, and you're writing editorials to the newspaper, and somebody says something nasty about you. And you sue them. And they defend, you're a public figure. You say, I'm not a public figure. I'm a plumber. You have probably temporarily become a public figure because of insertion into that public debate. We'll talk about all that and more. And if a parent accuses a child of being in the thief, of being a thief, well, that's tough luck.
Yeah,
and you just get the punishment. You just get the punishment I give out to you.
Why can't a child sue?
Because you can't.
It wouldn't be in their best interest.
Because I'll lock you up forever. Anyway, that basically does it for today's Ask a Lawyer. I'm Stuart Address. My office is 781-8003. Cheryl's there waiting to take your calls. And stay tuned. Don't change that dial, as they say. Stay tuned for Ask a Rabbi, coming up at 11:05 with Rabbi Shafir Loeb of Congregation Eitz Chaim in Port St. Lucie, across from Met Stadium. Thank you very much for listening. I will talk to you again next week.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.